This is part 2 of Know Your Legal Consumer Rights. We're going to go straight into how a creditor must collect on a judgment that is received through a court of law. Collecting a judgment is actually harder than winning it. If a creditor has gone to court and won a judgment against you for collection of an unsecured debt, theoretically the creditor, now called a judgment creditor, will be able to take any cash in your business's bank account, your business income, and your business assets to pay off the debt. If you're a sole proprietor or a partner, or you signed a personal guarantor for a debt, the judgment creditor could also garnish your wages and take away money from your personal bank account, and vice versa, as well as take any non-exempt personal property to pay off the debt. However, to take money or property, the creditor must first locate it and then get a court order and pay the sheriff to take it. Probably the most common collection method is for a creditor to obtain a writ of garnishment, under which a sheriff could garnish 25% of your wages to pay the debt, except for in Pennsylvania, South Carolina, and Texas, where garnishments are not allowed at all. But assuming you are a self-employed business owner without a side job, garnishing your wages would be pretty difficult since you don't get an actual paycheck, unless you're an employee of your own corporation. However, on the personal side, since you are generally working for someone else, it's much easier for them to garnish through your employer. Your spouse's wages could also be garnished to pay your business debts. If you live in a community property state like Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin, assuming your spouse is named in the court judgment. Often a more effective collection technique, if your business sells goods or services for cash, is for the sheriff to come to your business and take any money he can find. So, for example, in the register, that's called a till tap, or on your person, or a sheriff could be authorized to take business vehicles, equipment, or tools of the trade to pay your debts, something that will happen only if those items are clearly worth more than you owe on them. It's also possible that the creditor could get a court order for your bigger customers and clients to pay any money they owe you directly to the court. However, most creditors won't go to these lengths to get your property. Instead, many just simply attach a judgment lien to real estate or assets. If you are personally liable for the debt, then the lien will allow the creditor to collect the debt when you sell or refinance property. You can check to see if there are any liens recorded against you or your business with the Secretary of State's office. If you do have regular wages coming in, perhaps from a side job or because you are an employee, your wages can be garnished to enforce a court judgment. The total amount your creditors can take from the wages is 25% of your net pay. That limit applies whether you have one creditor or many, and if your wages are low, there are additional protections. You must be left with weekly income equal to 30 times the federal hourly minimum wage. A few states have lower limits, but if you owe back child support or back taxes and your wages are being garnished, expect to lose a much larger percentage of your wages, 50% or more, depending on whether you are supporting others. Social Security checks, retirement plan proceeds, unemployment and disability benefits, or workers' compensation awards cannot be garnished, except to pay federal taxes or child support, or unless they have accumulated in your bank account and your bank account gets levied. One of the most misunderstood credit terms is the phrase charged off. You may have seen it on your credit report next to an old debt you might vaguely remember. At first look, it sounds almost positive, as if implying that the balance has been eliminated or in some form discharged, removed and paid off. In reality, though, it's a charged off account that can actually mean trouble for your credit report and financial well-being. Here are the important things you need to know about charged off debts. First of all, what it means. So what is a charge off? Creditors, like any company, have profits and losses every year. A creditor's profit depends on how successful they are in receiving timely payments from loans and collecting interest. Their losses commonly will be the result of someone not paying back their debt for a significant amount of time, and when this occurs, the creditor will charge off the debt, essentially saying that they don't expect it to be resolved and declare it a loss for the company through the IRS. When does that happen? Exactly when that happens is generally somewhere between 120 days to 180 days of them attempting to try to collect the debt from you as the original lender. Do you still owe the debt once that debt's been charged off? Just because an account has been charged off by creditor does not mean that the debt has been wiped away, unless, of course, you file for bankruptcy and included that debt in your filing. Creditors still retain the right to collect the full amount of the debt and have a variety of options available to them in order to do so. Depending on the situation, creditors can utilize contacts from their internal collection staff, pass the debt off to an external debt collection agency, or if the debt is large enough, anywhere above the $2,000 mark, a creditor could file a lawsuit or seek arbitration. However, a creditor is barred from suing on a debt that is past the statute of limitation. And what we're going to do now is actually go through the list of statutes of limitation on debt collection by state. As mentioned before, every state has a statute of limitation that limits how long a creditor or a debt collector can successfully collect a debt. In California, for instance, the statute of limitations varies based on the type of lawsuit. A breach of a written contract is given 4 years from the date the contract was broken, while property damage allows 3 years from the date the damage occurred. Typically, the statute of limitations starts when you miss your first payment with the original creditor. It does not start when the account was placed for collection. If a debt collector tries to sue you after this time period has expired, you can raise the SOL as a defense against the lawsuit. Many consumers confuse the length of time that debts can appear on their credit report with the debt collection statute of limitations. However, these are often two very different time periods. If you have debts that have been charged off and are in collection, it's critical that you get your credit reports to find out what is being reported. You can view 2 of your credit report scores on credit.com, but those are only the scores. You really need the hard copy mailed to you from all 3 of the credit bureaus. Not only will this give you helpful information about the dates you fell behind, it will also alert you to the collection accounts or even judgments you did not know existed. Here are a couple of things that you can do before we get into the states. Number 1, go to annualcreditreport.com and see the specific information that is reported if you like. However, it's important that you order your hard copy credit reports so that this way you're actually able to see all of the account information. You can also find out whether these items are affecting your credit by checking your credit scores at the same website. At the website, annualcreditreport.com, you will find an area that states, in order to order your hard copy credit reports. There is a 1-page form there with directions, and that is. I'm going to go ahead and go state by state and let you know what the written contract statute of limitations is and the oral contract statute of limitations are for each individual state. Here we go. State of Alabama, written contracts have 3 years. Oral contracts have 6 years to be collected upon. State of Alaska, written have 3 years. Oral has 6 years to be collected upon. State of Arizona, written has 6 years. Oral contracts have 3 years. Statute of Arkansas, written contracts have 5 years. Oral contracts have 3 years. The statutes for the state of California, written contracts have 4 years. Oral contracts have 2 years. State of Colorado statute of limitations, Written is 6 years, oral is 6 years. State of Connecticut statute. Written contract 6 years, oral 3 years. State of Delaware. Written 3 years, oral 3 years. State of Washington, D.C., or State of D.C., written contracts 3 years, oral contracts 3 years. State of Florida, written contracts 5 years, oral contracts 4 years. State of Georgia, written contracts 6 years, oral 4 years. State of Hawaii, 6 years for both written and oral contracts. State of Idaho, written contracts have 5 years for collection, oral contracts have 4 years. State of Illinois, written contracts have 10 years, oral contracts have 6 years. State of Iowa, written contracts have 10 years, oral contracts have 5 years. State of Kansas, written contracts have 3 years for collection, oral contracts also have 3 years for collection. State of Kentucky, written contracts have 15 years, oral contracts have 5. State of Louisiana, written contracts have 3, oral contracts have 10 years to be collected upon. State of Maine, written contracts have 6 years, oral contracts have 6 years. State of Maryland, written contracts have 3 years, oral contracts have 3 years. State of Massachusetts, written 6 years to collect, oral 6 years to collect. State of Michigan, written contracts have 6 years, oral contracts have 6 years to be collected. State of Minnesota, written has 6, oral also has 6 years to be collected. State of Mississippi, written has 3 years, oral has 3 years. State of Missouri, written contracts have 5 years to be collected, oral contracts have 5 years to be collected. State of Montana, written contracts have 8 years to be collected, oral contracts have 5 years to be collected. State of Nebraska, written contracts have 4 years to be collected, oral contracts have 4 years to be collected. State of Nevada, written contracts have 4 years, oral contracts have 4 years. State of New Hampshire, written contracts have 3 years, oral contracts have 3 years. State of New Jersey, written contracts and oral contracts both have 6 years to be collected upon. State of New Mexico, written contracts have 4 years, oral contracts have 4 years. State of New York, written contracts and oral contracts both have 6 years to be collected upon. State of North Carolina, written contracts have 3 years, oral contracts have 3 years to be collected upon. State of North Dakota, written contracts have 6 years, oral contracts have 6 years to be collected. State of Ohio, written contracts have 6 years, oral contracts have 6 years. State of Oklahoma, written contracts have 5 years, oral contracts have 3 years to be collected on. State of Oregon, written and oral both have 6 years to be collected upon. Pennsylvania, written contracts have 4 years, oral contracts have 4 years. Rhode Island, written contracts 10 years, oral contracts 10 years. South Carolina, same thing, 10 years for written, 10 years for oral to be collected upon. South Dakota, written is 6 years, oral is 3 years to be collected. Tennessee, 6 for written, 6 for oral to be collected on. Texas, 4 written and 4 oral to be collected upon. State of Utah, 6 written, 4 oral years to be collected upon. State of Vermont, 5 written contracts, 5 for written contracts, 3 for oral contracts. State of Virginia, 6 and 6, 6 for written, 6 for oral contracts to be collected upon. State of Washington, 6 written, 3 oral to be collected upon. State of West Virginia, 10 for written contracts, 10 for oral contracts. State of Wisconsin, 6 and 6, so 6 for written and oral. State of Wyoming, finally, 10 years for written contracts, 8 years for oral contracts. Keep in mind, this has to do with when a collector can no longer collect from you by suing you, okay? So that means that from the point that you miss your first payment until that statute is up, you cannot be sued after the statute is up. We'll go into more detail about this with my video tomorrow. Have a great afternoon.